The next question here, we got a series of questions actually for a lot of our members are very interested in what's going on with various pending court cases. So this first one here from David, he wants to know what's taking so long with the Bianchi case out of Maryland, which is the assault weapon ban case that the Supreme Court granted, vacated, and remanded after it decided the Bruen case last June, sent it back to the Fourth Circuit and said, reconsider this case under the new Bruen test, and we still haven't had a decision. So he wants to know, what the heck's taken so long? And he also asks about, various other cases around the country because it's sort of a similar situation there. So do we have any special insight on what's taking the court so long?
Yeah, do you?
I was going to say it's. I don't really have a line to the minds of these judges. Unfortunately, that's just sort of the way it is, especially in the federal court system. It's also worth keeping in mind that it's only been a year, right? And in legal terms, a year is not that long for legal cases. For most people that are on the edge of their seat, wanting to hear the conclusion of these cases, that can feel like an eternity. But in the grand scheme of things, that's not uncommon in the legal system. So it's just kind of one of those things where you have to wait and see, unfortunately.
Yeah, I mean, it's very similar to the Supreme Court itself, where you can try and read tea leaves, but oftentimes it's a black box what goes on inside of there as to why they take the cases they take, or why they do it in the order that they do it, and why it takes so long for some of these lower courts to issue rulings. You could think, well, maybe it's some sort of strategic thing. Maybe maybe the Second Circuit, I believe that is, or the Fourth Circuit, sorry, in the Maryland case, where they don't want to be the ones to issue the ruling because they think their ruling is not likely to survive at the Supreme Court, and they're not willing to, adjust their thinking, or maybe they want to see what it could be similar to what's going on with the Supreme Court itself with these GVRs, granting, vacating, and remanding certain cases. I think they do that because they want to see how the lower courts handle these things, what arguments come up, and what opinions get drawn. And so maybe part of the waiting for a number of these cases, there's a number that are, where you've waited months since arguments have been held and there's still no decision. They might be trying to suss out how the courts are coalescing on these different cases. That could be part of it. I mean, hopefully that's not it, but that's, wouldn't be outside the realm of possibility that there's this sort of strategic litigating going on with how these decisions are made. I mean, you can see that, in my opinion, in the Illinois Supreme Court case about their assault weapons ban, where the court, you could blame this on the way that the plaintiffs argued the case, but the court sidestepped the Second Amendment issue altogether. And, by doing that, they kind of reset the clock on any potential Second Amendment challenge, at least in the state courts, to their assault weapons ban. And I think one, at least side benefit of doing that is they don't risk the chance of having that case go to the Supreme Court and being overturned. Because I think a lot of these judges don't want to have a record where they're constantly being overturned. So it could be that. You have Benitez, too, in California, which I believe David asked about him in the same vein. And, yeah, I mean, I don't know why he's waiting. Right? Nobody knows. He doesn't tell you, right? But maybe he's waiting to see how the Ninth Circuit, how some of these other courts are handling the Bruen decision and the Bruen standard. His previous rulings had kind of anticipated this history and tradition test that came down in Bruen. That it wasn't a brand new creation of the Supreme Court in 2022, right? This was a concept that had been floating around in the lower courts for a while. Kavanaugh was kind of the one who coined it back in the second Heller, DC v. Heller case, where he was in a dissenting opinion. But, Bruen Benitez in California had already used that basic logic or the basic standard to strike down, I think it was the magazine law, their magazine limit. So, it's not like he isn't familiar with the case law or the concept, but yeah, I don't know. I don't know why he's waiting. It's a lot to say. I don't know, I guess.
Right. But this kind of brings.
But we have another question here.
I was going to say the kind of similar, both David had another question and Paul about two separate cases that might have, be a little bit more satisfying for folks watching this stuff. So Paul asks about the Second Circuit when they might rule on New York's Bruin response carry case. And then David asks about the timeline of the Seventh Circuit in that's the federal case dealing with Illinois' assault weapon ban. And I think what's interesting about those two is that the Supreme Court has already kind of established that they're watching those cases, because in both cases there was an attempt to get emergency or early intervention from the Supreme Court. And so in both cases, they were put on expedited review is what they call it. And, people shouldn't get over their skis about what expedited means. That still means, several months instead of, over a year or what have you. But it's a good chance that you might see rulings in those cases perhaps earlier than some of the other federal cases that are going around right now, just because of that fact.
Yeah, I think that's right. You could still have the same basic complaint about the Second Circuit, right? They're supposed to be on this expedited schedule, but we haven't seen anything from them yet. But I do think that you're making a really good overall point here about the, court time. Court time is not the same as the time the rest of us run on, right? These cases can usually take years to process through the courts. And a lot of people, once they saw the Bruin ruling come down, and I think a lot of gun rights advocates saw that as a very favorable standard and took it as the courts, recommitting to focusing on this issue. And there's some people get this expectation that they're just going to take 5 or 6 Second Amendment cases a year. And that's not realistic in my mind, at least. First of all, they've already taken another Second Amendment case just a year after the last one. Now they have a lot to make up for, right? Because there's only been, I think it's 6 now, Supreme Court cases that deal directly with the Second Amendment. And only a couple of those have produced actual rulings that are significant precedent. Whereas you look at the First Amendment or the Fourth Amendment or the 14th Amendment or many of these other amendments to the Constitution have had so many more cases, hundreds and hundreds of cases for the court to, opine on the limits of the protections offered there or what have you. And so, they have a long way to go, but at the same time, I don't think that means they're going to just try to make all that ground up in a year, right?